5, 4, 3, 2, 1. Yet another judgment also in brought to the knowledge of this court by the learned counsel appearing for the writ petitioner passed in WA number 43 of 2015 on 20/10/2015. In this case also, the application was submitted on 29/4/2000 seeking compassionate appointment of the deceased employee who died on 2/1/1994. However, the Hon'ble Division Bench has not discussed and adjudicated the entire legal principles with regard to the scheme of compassionate appointment. Contrarily, the order was passed based on factual aspects. The Honorable Supreme Court in the matter of compassionate appointment has rendered a judgment setting out the principles, the guidelines, and the scope of providing appointment on compassionate ground. Compassionate ground being an exception to that of the general recruitment, the same should be provided with all caution, taking note of the fact that compassionate appointment will certainly deprive the eligible meritorious youths and citizens of the country to get public employment. When the courts are providing an exceptional scheme of compassionate appointment to the individual, it is equally relevant to keep in mind that such facilities provided should not affect the rights of other citizens who are otherwise qualified, meritorious, and aspiring to participate in the open competitive process. The granting of relief, if it affects the constitutional rights of other citizens, then the courts must be slow in granting such relief. The consequences, impacts, and the denial of rights to other citizens are also to be considered while extending relief under such an exceptional scheme of compassionate appointment. It is not the case as if the courts should stretch off the scope of compassionate appointment based on an unwarranted sympathy or leniency. No doubt, the Court of Justice has to consider the factual circumstances and, if necessary, certain relief can be provided. However, any such sympathy or leniency shown to a particular person should not have any adverse effect of affecting the rights of other eligible citizens who are waiting and longing for public employment in this great nation. Thus, this court is of the view that a striking balance ought to have been adopted in such circumstances, and court in its wisdom has to analyze the possible direct and indirect impacts in this regard in order to provide equal opportunity in public employment to all the citizens. The courts are bound to bear in mind that equality clause also to be weighed before stretching the scope of such an exceptional scheme of compassionate appointment. Thus, this court cannot consider the orders produced by the learned counsel for the writ petitioner, and this court has to follow legal principles and the precedents settled by another division bench of this court in the case of Inspector General of Prisons versus Sudhakaran 2015 4 CTC 124 and all other judgments of the Honorable Supreme Court of India in this regard. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.